Good evening, class, professor. My name is Jessica Baptist, and I'll be presenting the case of Terry versus Ohio of 1968. So, jumping right into it, Terry versus Ohio was a landmark case that provided the name for the Terry stop. It established the constitutionality of a limited search for weapons when an officer has reasonable suspicion to believe a crime is afoot based on the circumstances. Terry versus Ohio. The the Okay, so under the Fourth Amendment of the U.S. Constitution, a police officer may stop a suspect on the street and frisk him or her without probable cause to arrest if the police officer has a reasonable suspicion that the person is committing or is about to commit a crime and has a reasonable belief that the person may be armed or presentably dangerous. A little background a little case of the background, a little background of the case. The case of Terry versus Ohio is based on the events in Cleveland, Ohio. On October 31st, 1963, Detective Martin McFadden saw two men, John W. Terry and Richard Chilton, who McFadden stated were acting suspiciously. He saw them proceed alternatively back and forth along an identical route, pausing to stare in the same store window, which they did for about a total of 24 times. He saw them walking back and forth on the same block before they would stop and talk with each other. After watching them repeat this several times, a third man joined and conversed with them for several minutes before leaving. This made McFadden grow suspicious, so he decided to follow the men. Once all three men were together, McFadden, who dressed in street clothes, approached the men and identified himself as a police officer, asked for their names, and allegedly one of them mumbled. So he began to frisk Terry and discovered a gun. Upon finding the gun, he ordered the three men to face the wall above their heads and completed the stop and frisk. He then found the gun in Chilton's possession. All three men were taken into police custody, and that's when Terry and Chilton were arrested for carrying a concealed weapon. Okay, so there, it just gives you this background or whatever. Basically, a police officer observed. It's also, I've read on the case that he frequently observed this one particular location. So it's just in second nature to just patrol this certain part of the neighborhood in Ohio, and he stopped them, just because of a good feeling, and stopped, frisked them, and, found the guns. So, moving on. So, actually, Terry and Chilton were arrested and charged, but Terry was the only one to appeal, hence, that's why it's called Terry versus Ohio. So, John Terry, one of the men arrested, claimed that Officer McFadden lacked evidence and probable cause to perform the frisk. To engage in this action, Officer McFadden would need hard evidence that showed that the men were on the verge of committing a crime. John Terry claimed that the search was illegal because it invaded his right to privacy. John Terry's main defense lies in the Due Process Clause of the United States Constitution. The due process clause states that the United States federal government must uphold the legal rights and liberties of its citizens when they are arrested or taken into custody. So, the problem here, whether the search for weapons was a probable cause for arrest, is an unreasonable search under the Fourth Amendment to the United States Constitution. So, what exactly is the Fourth Amendment? The rights of the people to secure their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by the oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So, Was the search and seizure of Terry and the other men in violation of the Fourth Amendment? Um, in my personal opinion, I believe that uh, if it was just a judgment based off the officer judgment, then it wasn't a violation. It was probable cause. It was he had a suspicion, a good feeling, and it turns out that they were armed. But that's not saying just because they're armed meaning that they're about to commit a crime. It's just he had a good feeling and he went on it. He acted on it. So, in an 8-1 decision, the court held that the search undertaken by the officer was reasonable under the Fourth Amendment, and that the weapon seized could be introduced into evidence against Terry. Attempting to focus narrowly on the fact of this particular case, the court found that the officer acted on more of a hunch, like I said before, and that a reasonable, prudent man would have been warranted in believing Terry was armed and thus presented a threat to the officer's safety while he was investigating suspicious behavior. The court found that the searches undertaken were limited in scope and designed to protect the officer's safety incident to the investigation. So he went to the Supreme Court, and of course he lost because they believed that it was justified. So, like I just said, Terry versus Ohio. The United States Supreme Court in Terry versus Ohio ruled in favor of the state, claiming that Officer McFadden's search was initiated from evidence and reasonable suspicions. The United States Supreme Court therefore ruled that Officer McFadden possessed probable cause. The court viewed the two men as being a threat to society, therefore allowing Officer McFadden to conduct a search in Terry versus Ohio. John Terry's claim that Officer McFadden violated his privacy and conducted an illegal search was not upheld in the United States Supreme Court. The Fourth Amendment does not... Wait, I hope I didn't say, because it's hard to go back and I'm already at 7 minutes, that it went all the way to the Supreme Court. I don't know. I hope I didn't say that. But an illegal search was not upheld by the United States Supreme Court. The Fourth Amendment does not prohibit law officers from conducting search and seizures without probable cause. But in this matter, the court not only ruled Officer McFadden in possession of probably cause, but also viewed Terry and his accomplices as threats to society. I don't think it should have went that far as just saying they was threats to society. But I mean, I don't understand why somebody will walk up and down the street, 24 times, stopping and looking in the same store. I think you call it casing a place, trying to get familiar with it. So it was that gave the officer a reason to be suspicious. So it's in nature, if you suspicious of anything, check it out. So just a little background of why the court made the decision that they made was a distinction should be made between a stop. Well, I'm sorry. This is more of why the judgment was what it was. And this is how Terry defense was looking at it. Distinction should be made between a stop and arrest and between a frisk and a search. Thus, it is argued the police should be allowed to stop a person and detain him briefly for question upon suspicion that he may be connected with criminal activity. Upon suspicion that the person may be armed, the police should have the power to frisk him for weapons. If the stop and frisk give rise to proper cause to believe that the suspect has committed a crime, then the police should be empowered to make a formal arrest and a full incident search of the person. This scheme is justified upon the notion that a stop and frisk amounts to a mere minor inconvenience. Okay, so was the ruling really fair? To me, times have changed. So back then, yes, the ruling was fair because, like I said, walking up and down the street, casing a place, um, and you're armed, and you are with an accomplice. It's not like you was by yourself. Like, you can easily justify walking up and down the street yourself. You can say you pacing, you stressing, but you have an accomplice. Y'all armed, and y'all keep looking at a store. Okay, yeah, that's suspicion. How has this crime helped in the last 50 years? I believe that actually, um, I'm kind of against the Terry versus Ohio now because times have changed. A lot of people have lost their lives because a police officer was suspicious. Um, Countless homicides and or justifiable deaths when a police officer pulls somebody over, just because they was suspicious. I believe that it should be it should be very detailed of why you were suspicious. Like, just because of a hunch, I think now it should be more of a hunch with a little bit supported evidence. Just like how, well, that's kind of contradicting. I don't know if I'm explaining this right, but just the way he viewed them stopping and looking in the store, I feel like now the Terry versus Ohio is being abused. I feel like they say, well, he was suspicious, so I'm gonna act on it because I just feel like now it's so much going on between citizens and the police officer with no trust and you know a lack of just a lack of trust, and I feel like policemen are racially profiling. I feel like they're stereotyping, and I feel like Terry versus Ohio kind of give you a little leeway to abuse authority. So I feel like that, yeah, it may be looked at upon as a minor inconvenience, but it's that minor inconvenience, that's what tears our trust apart. Like, a police officer stopping me because he thought that now, case in point, I don't know how many people have ever got pulled over for this, but I've been pulled over myself. I know about 2 times. We range your place and it's coming back as your car is not registered. I have up to date tags, and now the tags come with your license plate number on there. All of that information is there, but I'm still being pulled over because, quote unquote, in the system, my car is not being registered. It's an inconvenience, but I feel like it's a lie. Like, I know it's a lie. How is my car not being coming up as being registered? I feel like those the kind of things that Terry versus Ohio. Like, I feel like that gives them a leeway. But I was pulled over because my tags wasn't coming up as being registered. So I feel like that in the last 50 years, crime has changed, criminals have changed. I feel like that it should be a little more to allowing police officers just to stop us because of a hunch. Like, I'm kind of agreeing with it, but I think now, in this day and age, we need just a little bit more than it was just because he was suspicious. We need something hard, concrete. You know, even just going as far as this is what the officer said he seen. I think it should be something like he should have recorded this is what he was saying. I don't think it should be based on I don't think it should be solely based on upon what an officer say. I feel like in this day and age, in 2019, we want to see it. We want to see it. They have body cams now. Record it. So you seen them walk up and down the street 24 times. Record it. Let us see. So I don't know. So I guess it kind of make more of a trust factor between us. But I feel like it definitely should be revised. I feel like all cases that's significant in criminal justice history should be revised because, like I said, times have changed. The last one, which I think I already kind of went through, was, does the Terry versus Ohio ruling give law enforcement a pass to abuse authority? Yes, I do. I do think that. The example I gave, yeah, man, we're pulling you over because your registration isn't coming up in the system. And it's just like, it's not coming up in the system. Well, where did I get a sticker from that has my license plate number on there? I don't think you can only get them from one place, and that's the DMV. So I feel like, yeah, it do give them the pays to abuse authority. You know, yeah, he do. Well, that was my case. I hope I made it clear to you guys. I hope I hit all the points. Um, if you have any questions, comments, or anything, I'll be more than willing to answer them and engage in conversation. Thank y'all for listening.